gunshots, gunshots. Breaking news, breaking news. Today in this class, this is our paralegal class. We're going to break down the plea agreement. What a plea agreement is when someone decides to cooperate with the government or the state. In this situation, it's the state, but it's the same thing. If you're already subscribed, please, all I'm asking you to do right now is hit the notification bell. If you just subscribing, I'm again asking you to please hit the notification bell. We're going to break down what a plea agreement is, and we're going to see how a plea agreement goes wrong. Watch this to the end. You'll see how you hear one side and then you hear the other side and how your mind is swayed. And that's why they tell you to hear out all the evidence before you make any determination. Because the examination of the witness, meaning when they first on the stand, is one side, and then there's a cross-examination where the attorneys for the defendants get to cross-examine the witnesses about what they said. Do you understand that? If not, rewind that. I will not be repeating myself. This game is too valuable and I want to stay on course. Let's get this party started. All right. All right, Unique Mecca Audio, man. I'm here. We're going to break this joint down. We got Monk Tunk on the stand. We had little Woody before. That's why I showed him. We're going to play this video. And this is where Monk Tunk is not performing as the government intended him to perform as. So they brought out his plea agreement to remind him that he's facing, yes, 35 years in prison. He's not getting sentenced until after the trial. And if Miss Love is not satisfied with the performance that he performed on the stand at the trial, which he's doing now, he will not be getting the sentence that he agreed on. He will be getting the 35 years. So she's reminding him that you're looking at 35 years, you're playing games with me, you're being too intelligent. Stop the crap. That's what she's saying. Stop the crap. You know what I mean? You're looking at 35 years. Let me remind you. And this is the reminder. Let me play this tape and I'm going to let you hear what's going on. All right?
Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, Counsels Love and Hilton.
All right, before we go any further, let me let you know now. This is Judge Glanville giving him his plea agreement that he signed to get out of jail. Because what happened is they locked up Monk Tunk, right? It appears on this indictment, and they're saying that we're going to take you off the indictment if you agree to work with us. Okay? Now, he agreed to work with them based on this agreement that we're getting ready to play. And this is what he agreed to do. Now, this is not what he's doing in the eyes of Miss Love. So this is how it's playing out. But this is Glanville taking his plea back in December 28, 2023. So sit back and listen. That's why you hear Judge Glanville. Then we're going to go over to what's happening today. So pay attention. I just wanted to give you all a recap. I didn't want y'all to think that I was bashing Monk Tunk. I'm not bashing Monk Tunk. I'm just being a journalist and I'm reporting what's going on. And it's not looking good for Monk Tunk. All right? Monk Tunk thought it was going to be a game, a walk in the park. He did what he had to do to get out of jail, the same as a lot of you would. Now, if you feel that what he's doing is right, put it in the comment. If you feel what he's doing is wrong, put it in the comment. I want y'all to talk to me today. If there's anything you want me to report on, please send it to my number that's going to be on the screen. The number is 917-680-9091. And from there, I will put it up. And if you want your name to be said that you sent me this information, put that in as well, and I will give you a shout out. Now, let's get back to the plea agreement.
Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right. Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing should be the truth, the whole truth, nothing but the truth, so be God or so firm?
Yes, I do.
All right, you put your hand down, sir.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Moontum, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon.
Okay, so you understand. The RICO, which is the Racketeer Influence Corporation Act organization, you know what I'm talking about, the RICO. Now, what they're saying is that carries a minimum of 20 years. The gun that he's charged with carries a minimum of 15 years. So he'll get a minimum of 20 years, which being that he's just in the conspiracy, so that he's looking at 15 years, not 20 years. And then the gun carries another 15 years. The reason why it carries 15 years for him and not 5 years is because he's a convicted felon in possession of a gun prior to this gun that he's charged with. So that brings it up to what they call a career criminal. A career criminal means that your time starts at like 12 years, 3 months, something like that. You rat bastards, correct me if I'm wrong. And my loyal subscribers, feel free to do the same. All right, it is going to be respected for my loyal subscribers and my temporary tapping in viewers. Now, let's finish this up. All right.
Yes,
As
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
All right, I stepped out the way so that you can see the attorney. The attorney is going to be praying for this man, Monk Tunk, at this point in the trial, and you're going to see that. I'm going to point that out.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Look at his attorney's hands right now where they're at on the table.
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Now, the gun that they're charging about, listed in count 30, carries 15 years by itself, and that runs consecutive. So he's looking at 30 years. So he's testified for his life. I know when no one else told you about this, but he's testifying for his life right now. because 25 years is considered a lifetime, and I did 26, and I sat there like Young Thug, so I know what he's feeling. Believe me, I'm going to do a video about how Young Thug feels. I'm going to get some clippings from Young Thug, how he's looking during the course of his comrades that he looked out for testifying against him.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
All right, so what they're doing now is they're going over the course of this plea agreement so he understand that his life is on the line and they don't like what he's testifying to. And the prosecutor, Miss Love, is getting it on the record that he's not cooperating with what he signed the plea agreement for, what he told them and agreed to on the plea agreement. Now, he's going to go on to saying that this is what they wrote up. He didn't really understand it. That's why it went in the way it's going. But pay attention to the lawyer's hands, how he's going to be praying for his client.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Now, before he answer, I want you to understand so you can walk through this with me. They're asking him, did he get a chance to speak to his attorney about this? Now, when he says yes, whatever he say he don't understand, they're going to put it on his attorney and call it ineffective assistance of counsel because he did not explain to him, and it was his job to explain to him what these words mean that he's going to say he don't understand. So they're going to wind up having to call the attorney on the stand for the attorney to try and save his integrity by saying, I did explain to him what the outcome would be if he don't testify in the manner that he's signing this plea agreement to, that the lawyer is going to be breaking down to him in private. He's saying that his lawyer did that and he's represented by attorney. Now.
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you
See, when she asked him, does he need more time to discuss this? That means that if there's anything in this, this is on December 28th, 2023. They're letting them know if there's anything in this you don't understand, you can ask your attorney now. And that's going to be her defense when she try and give him this 35 years to say that he's not participating with that. Because at the end of this video, one of the lawyers is going to get up and they're going to cross-examine him about how he didn't understand what was in the agreement. He didn't understand certain words in the agreement. So that's where that's at. And she's setting the trend for where she's going with this. All right?
satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive?
You hear that? He waived a formal reading of the indictment. By him waiving a formal reading of the indictment, that means that she don't have to read each thing that he's charged with, that he's going to say that he read on his own, that he did not understand certain words like coercion and, like, I think it's furtherance. It's going to come up when I point it out. But just pay attention to this. So she's giving him a chance right now on December 28th, 2023. And he said, no, ma'am, I don't need you to read the indictment. I mean, the plea agreement. I understand the plea agreement. Let's go.
Any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
Right there. The lawyer reached over to tell him no. That's the lawyer telling him to say no. He do not know of any other charges, because if he did know of any other charges, it was his duty at this time to let it be known, and they will incorporate it in this plea agreement. So whatever he don't say that he may know of, then they will be able to use it to charge him for a new crime because they're going to say they gave him a chance to speak about any warrants or open car cases that he had at that time. Pay attention. You ain't going to get a better analysis than this.
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
You see how he answered that before she even asked the question? They're going to go back to that in the end, so pay attention to this. Him answering the question
Do you
before she asked.
understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
All right, so this is a negotiated plea. A negotiated plea is that we're negotiating right now what your sentence will be, but then they're going to speak on that they're not going to announce the sentence until after the trial is over. So if they're not satisfied with the manner that he testified in, then the negotiation would be that he would be facing 30 years in prison, but she put down 35, which you're going to see later, and there's no reason why it went from 30 to 35. I assume, which makes an ass of you and me, I assume that that extra 5 years is going to be for the perjury. That will come out at a later time and date. And then you'll tell me if I'm right or wrong if I know the law. If y'all need me to break down these cases and you got these major podcasts, feel free to reach out to me. I know I get a little antsy when I deal with the rap bastards and flip-flopping and public trolls, but I'm passionate about this. So I apologize.
As to count 1, 15 years to serve on probation subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case.
Right there. Sentencing will be held until the completion of this official trial in place. Her exact words. That means if you don't testify to my satisfaction, you will not be getting this plea agreement and you will be looking at 35 years in prison. Don't know where the 35, the extra 5 come from in the 35, but we're going to find out about that at a later date. So listen up. You heard that. If you don't testify in the manner that we want you to, that means that this is null and void.
After the trial of this case, after the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30.
That means if he testify like he's supposed to and give them everything they want, that they're gonna withhold and pull off the count 30, which is the convicted felon in possession of a gun, and that's how they're gonna give him his time. But if not, they're gonna give him that daggone gun.
Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment.
Now, she's saying, do you understand that the court don't have to accept this agreement if you violate the conditions of this agreement? That's what she's saying right now, so you fully understand. They don't have to accept this, but they will if you testify like we expect you to, and we make that determination.
Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Meaning, if the court don't accept what you're saying because you don't abide by what we have in this square document that I'm reading at this moment, that we could pull back our plea agreement and sentence you to the maximum extent of the law. That's what she's asking them. Pay attention.
Yes, ma'am.
Look at his lawyer now. Watch his hands. Watch his lawyer. Lawyer praying for him. Oh, God, please help this man. Watch his hands.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Pay attention. This is deep.
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
This is plea agreement that he signed December 28th, 2023. Watch his lawyer.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
See, she asked him, did he get a chance to review everything from 1A to 1F? So therefore, he can't say he don't know. So she's going to remind him of this later on in this video, and that's what's happening right now on the trial. So you're going to get the best breakdown of what's going on. All right? That's why I keep stopping the tape, so you rat bastards that feel you know this but haven't been through it, you could, right now, I'm going to give you 3 seconds to tap off my channel. Take that with you on the way out, because we don't want you here. I don't need you to support my book. That's on the right side of the page. But for everyone else, cop my book at Aurora in Harlem, at aurorainharlem.com, at Google and Bing. But you rat bastards and flip-flop public trolls, don't cop my book. I'm ordering you, don't buy my book.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133.
That's the one they holding over his head. That carries a minimum of 15 years, and that's what they're telling them. Not only does it carry 15 years, they cannot run that concurrent. It must be run consecutive because it was a firearm in the possession of a felon during the course of a crime of violence. Let's go.
The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until the years on probation. It has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement.
Now, what she's saying is that we're going to hold the sentencing over your head of count 30 of the felon in possession of a firearm, right? Until after the completion of your sentence, if we are satisfied with your testimony. And she's reminding them that we are not satisfied with your testimony. That's why I'm bringing this out, to try and get you back on track to do exactly what you said you was going to do, and that is to cooperate fully and truthfully with the state. Pay attention. Let's ride.
The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30.
Did you hear that? So he pled guilty to count 30. They're telling them after the trial, if you testify in the manner we expect you to, based on the 4 corners of that plea agreement, that you'll be able to pull your guilty plea back on that gun that's carrying 15 years consecutive, and then will be able to re-sentence you on that gun by dismissing that gun. But you got to be a good boy. All right, Mr. Sledge, that's what they're telling you. Let's pay attention.
The special conditions of the sentence, as outlined in Section 3, are that defendants shall abide in full by each and all of the terms of this negotiated agreement. Defendants' failure to abide by any term of this agreement shall constitute a violation of the agreement.
Now, she said if you don't testify in the terms of this agreement, based on what's in the agreement, that we can pull back this agreement and give you the 15 years for that gun, running consecutive, meaning bow-legged, separate, you know what I mean, to the 15 years for the RICO. Pay attention. He is between a rock and a hard place, and they're going to mention that later.
Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment.
There go the lawyer.
In accordance with testifying truthfully about all matters relating to this case,
watch his hands.
Defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment.
Right there, look at the lawyer. He's praying for him. He's praying for this man because he know that he hasn't been truthful with what he agreed with him back on December 28th, 1993 at the initial negotiations of his sentencing. So his lawyer is praying for him right now because she done hit him with the rock. Check it out. All right.
Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within Section 4 of this document?
Now, those initials that she's asking for is the statements that they wrote up that they said they got from him and from the investigation of the trial, and that he initialed that these are true and this is what he's going to testify to. Now he's going to say that, no, those are not true. I don't know all of that, but I signed this plea agreement because I didn't understand, a couple of words. All right?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows.
Mr. Sledge,
Yes.
for the purposes of my questions to you right now, if you disagree with any part of any one of these statements, we will call that, for the purpose of this question, false. If you agree that the entire statement is true, we will call it true. Do you understand what I'm saying?
Yes.
All right. So, understanding that, number one, is it true or false?
True.
Number two, is it true or false?
True.
Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend.
Number 3, is it true or false?
True.
All of it.
Yes, true.
Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang.
Number 4, true or false?
True.
See, she's getting him to admit to each thing that he agreed to. Pay attention to this. This is deep. I'm going to break this down.
Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Number 5, true or false?
True.
Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above.
Number 6, true or false?
True.
Listen.
Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder.
Number 7, true or false?
False.
Pay attention.
Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL.
Number 8, true or false?
False.
Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low.
Number 9, true or false?
False.
Okay, so y'all understand what's going on, right? When he's in this black shirt, that's what happened last week, right? That's what he's testifying to now. Now, we're running back, right, with the, with the help and the blessings of Paralegal Institute of Washington, D.C., right? This their video that I'm playing. Got to give them a props. If y'all need me, I'm welcome to come on there because y'all looking at it from a paralegal point of view, and I'm speaking from a paralegal and a criminal point of view. So you understand how criminals think, because that's what you all have people like me come to your school to testify, excuse me, watch my language, to make speeches about what goes through our mind in these type of situations. But I'm giving it to my subscribers and the people that tapped in, free of charge. And the rat bastards and trolls is not welcome. Not saying anything and giving my opinion. I'm leaving my opinion out of it about somebody that rat. You know what I mean? But y'all already know how I feel about it. But when a person rat and don't want to admit he rat and try and sign a plea agreement in the cuff, thinking that it would never come to the day of light because the case won't be televised, and then he try and justify his actions, that's what we call a rat bastard. So y'all decide who's a rat bastard and who's not, now that you know the terminology. Let's move forward, all right?
Number 10, true or false?
I can say true.
Number 11, true or false?
True.
Number 12, true or false?
True.
Number 13, true or false?
True.
Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Now, looking at page 5, the sentencing acknowledgments, if you today understand the whole sentence, tell me, yes, I understand. Because my question is going to be, do you understand each of these sentencing acknowledgments? Okay?
Yes.
All right.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding.
See, what she's saying right there, so y'all understand, she's pointing it out to the court that we're going to give him this 35 years he signed to in the plea agreement because he's not upholding the agreement in the plea agreement, which is to testify about the list of things that we numbered and laid out. Being that they numbered and laid them out, he looked at it, he put an initial next to each one, and he said that's what it is. So that's what he was saying that he agreed to testify to. Now they're asking him while he's in the black shirt in this video, what happened? And now he's saying all these different excuses. They're not trying to hear it. So we're running you back to the initial plea agreement when he saw that he had to testify to this, and he agreed to that in order to get this count 30, possession of a firearm in the hands of a felon, you know what I mean, in the course of a crime of violence, which is the RICO, dismissed. But he pled guilty to it. So now he's going to be sentenced after this trial. Miss Love is letting him know, right, that she's pissed. She's not going to give him the sentence that he expected to stay on the street. She let him go and that was her violation, right? Let me ride. I ain't ride yet. We've been on 37 minutes. I ain't even ride. Let me ride. Now, doing my joint, right? Show you how I'm connected to this and I fully understand this. All my co-defendants, when they decided to be rat bastards, flip-flop, weighing in public, roll over with the government, rat snitches, or whatever you want to call them. You know what I mean? She kept their black ass in jail. That was to keep the pressure on them. You're going to hear about pressure later. See, what Miss Love did as a rookie prosecutor, she released the pressure off the rats. That's why Woody was allowed to go free with the immunity, and that's why Woody did what he did. If Woody was still in jail during the course of all of this, for the 18 months when this happened, that boy would have went out there and sung better than Stevie Wonder. But she let him out, so he's singing like the local person at the karaoke. You know what I mean? Playing games with him like he don't know how to sing. And that's what they're doing right now to Mr. Monk Tongue. So you understand.
So number 1, do you understand today, number 1?
Yes.
The defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison.
Number 2, do you understand number 2? Yes or no?
Yes.
Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law.
Number 3, do you
See, now, what they're talking about is that count 30 that's looking at 15 years running what we said was bow-legged. You know what I mean? Separate. All right? That's where we at. She letting them know that I'm going to get you for this for the maximum standard of the law unless you tighten up. So now y'all watch from today forward and you're going to see a whole different Monk Tongue. All right? Because she's reminding him that, yo, you pled guilty to get out. I let you out. I didn't keep you in jail like we did in Unique Mecca Audio's trial to force you to do it because I trusted you. And now you violating that trust, Mr. Sledge. That's what Miss Love is saying.
understand number 3? Yes or no?
Yes.
Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment.
You see, she's letting it be known that, yo, I put in this agreement that I'm reading that you signed and initialed that you're going to speak about these initials and you're going to speak truthfully about it. And if you don't do that, I could lock your black ass up. That's what she's saying. I'm sorry to be so raw, but this is a gangster channel. We don't worry about views. We worry about reaching the youth and the elders that's violating the law so they know to get off the street and stop it. Let's move forward.
Number 4 on page 6. Do you understand number 4? Yes or no?
Yes.
Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections.
Right there, she's reminding them, you looking at 35 years in prison. Stop it. Stop it. That's what Miss Love is telling them right now. All right, so you understand. I'm going to put your ass in jail for 35 years if you don't tighten up. So they're going to bring him back on the stand after this, and we're going to see a whole new Monk Tongue. All right?
Or prison.
Number 5. Do you understand number 5? Yes or no?
Yes.
Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document.
Number 6. Do you understand number 6? Yes or no?
Yes.
See, this is modern day action if you understand number 6, and then they're going to go back to the plea agreement in number 7 and move forward back and forth. So pay attention, please.
Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you signed your name underneath?
Yes, ma'am.
See, right there, she's letting them know that you could confer with your attorney and you had a chance to confer with your attorney. So anything that went wrong is not my fault. It's your attorney's fault for not explaining it to you before you signed your name and put your initials next to these things that you agreed to testify to not get count 30. Y'all understand what I'm saying? Let's move on.
And the paragraph underneath number 6. Do you understand that paragraph? Yes or no?
Yes.
Do you need time to look at it some more?
No.
All right.
Your Honor, the state tenders as evidence, State's Exhibit 1AS.
No. Any objection? States 1AS is admitted for purpose of plea.
So, Mr. Sledge, as it relates to Part 5, beginning on page 5 of 7, and your understanding on December 28, 2022, if you understood all of it on December 28, 2022, please answer yes. If there was any part of it you didn't understand, please answer no, okay?
Yeah. I know what you're saying.
Number 1, on December 28, 2022, did you understand it?
No, I didn't understand, no.
See, now he's saying he didn't understand it, but you had a chance to speak to your attorney. She just said that earlier, that you got a chance to talk to your attorney if there's anything you don't understand. So whatever you don't understand falls on your attorney. I laid it out in black and white. I let you know I wanted you to be one of us. And now you're trying to be a criminal, but trying to get us to give you a deal. And we're not going to give you that deal, Mr. Sledge. That's what she's saying. Because you're not complying with your initials and your signature in this plea agreement.
Number 2, on December 28, 2022, did you understand?
No, I didn't understand that one either.
Okay.
Because I didn't even know I said that.
You see? And that's where they're going to say, well, if you didn't understand it, Mr. Sledge, you should have asked your attorney. That's why he was present. Stop it. Now.
Number 3, on December 28, 2022, did you understand it?
No, I didn't understand that one either, Ms. Lowe.
All right. Number 4, on December 28, 2022, did you understand it?
No, I didn't understand that one either.
Number 5, on December 28, 2022, did you understand it?
You just asked me about these same questions.
No, sir. I'm talking about back on December 28, 2022.
I didn't understand it.
You did not understand number 5 either?
No, ma'am.
You see how she's writing down what he didn't understand? And she's going to point that out and put it all on the attorney. That's why they're going to have to call the attorney to the stand and say, didn't you explain this to this dude? That's what you get paid to do. It's not my job to explain it. It's my job to lay it out, give it to you, and you go over it with your client and make sure he fully understands it. If not, that's ineffective assistance of counsel, not prosecution misconduct for not explaining it, because I gave it to your attorney that you had on the record. Let's go.
And number 6, on December 28, 2022, did you understand it?
No, I didn't really understand that one either.
The paragraph underneath number 6, on page 6 of 7, did you understand it?
No, because I never even read this. I didn't understand it.
You did not understand that paragraph?
No.
Well, that's what your lawyer should have read it to you, young man. That's what she's really going to get at. But right now, she's just laying it out, getting him to say what he needs to say, and then she's going to put it all on his lawyer for not breaking it down.
Okay. We're going to backtrack just a little bit. Would you please turn to page 5? And now, going back to the true or false answers. If any part of the factual acknowledgments I'm about to ask you about are untrue, then please answer false as it relates to today. If they are true in their entirety, please answer true as your testimony today. Okay?
Yes.
All right. Number 14 on page 507 under the section labeled factual acknowledgement. Today is your testimony that it is true or false.
Truth, I could say truth about that.
Say that again.
True.
Okay. Number 15, true or false?
True.
Number 16, true or false?
I say false, but I don't agree with everything they say in it, so
So
I say false.
okay. Thank you. Starting with the first factual acknowledgement you said was false. Am I correct that it was number 7 on page 407?
Yes, I told you that one was false.
Everyone before that was true. Is that right?
No, yes, I told you number 7, number 8, and number 9, and number 10 were false.
Number 10.
You said number 10 was false.
Yeah. Oh no, I said it was true. My bad. I had to read it over. I'm sorry.
Okay.
You see how he's apologizing? He's trying to do everything in his power to get this plea agreement. And he's trying to be respectful, but he's not testifying to the manner that he agreed to testify to.
So as it relates to number 7, is it the portion before the first comma or after the first comma that contains what you now say is false?
I say the one false by told.
Okay. So is
Yeah,
your
'cause
testimony
nobody-
that you were never told?
I was never told.
Okay.
But you initialed that you was told.
Number 8. Which part of number 8 is false?
If y'all want to know what she's doing, she laid out the criteria that was in his plea agreement, and this is what he agreed to testify to, and then this is what he testified to now in the black shirt, where he's trying to evade, answer the questions, and being vague, and she's not going for it. So first she got him to say what was true and what was false. So now she's going to go to what he said was false, and then find out why he's testifying they're false now when he had a chance to look this over with his attorney. Okay?
I misunderstood that the whole thing
What did you misunderstand? What do you mean?
because I didn't know it said personally. I thought when my lawyer was explaining, he said responsible. I never knew it said personally. No, because I can't personally know I wasn't there.
What do you mean when you say you thought it was responsible?
See, what they're getting at right now is your lawyer should have explained that when you was confused about the personal responsibility or you was told.
Because I was charged with it, Miss Love. That's why I was charged with the murder. So I was thinking like,
Were you indicted for murder?
No, I never got indicted for it.
Okay.
But I was
So
charged.
Yes.
That he be allowed to finish his
Yeah,
answers.
let him explain.
please continue.
Yes, I was charged by the DA office.
So how does that factor into your misunderstanding about the meaning?
Because I didn't know it said, it's a defenseless person and no one or more YSL member that committed the murder. I don't personally know. I wasn't there and no one never spoke it to me. So I can't say I personally know.
Okay.
If I personally knew I was there, I witnessed, I seen you do it.
Okay.
But other than that, I can't say I personally know that.
See, right there is where he was supposed to explain all of his concerns to his attorney. So they're gonna try and get his attorney on what they call what they call that ineffective assistance of counsel, and she's making sure they don't try and get her for prosecution misconduct for not explaining it, because she's going to say his attorney was there. It wasn't my job to explain it. It was his job to talk to his attorney with an attorney-client, confidentiality, and ask all of these questions at that time. Not to me in an open court when you're supposed to testify and now backtracking.
What about number 9? What part of number 9 is false? All of it or just some of it? As you testified today.
See, she's getting him on what he testified to today because she's going to try and sentence that ass to 35 years tomorrow. All right.
He gave YSL's associate money to lay low.
Now, this is where he's trying to help Thug out right here, right? He's trying to explain what the money was given to him for. So he's going to say what it was for. They're saying it was to lay low after you committed the crime to influence the activity of the RICO charge.
And that's what it say right there.
Is it your testimony today that the portion that reads he gave YSL Associates money to lay low is false?
Yes, that's false.
Mr. Sledge, do you have any recollection of asking?
Well, what I would say, the word, you used the word lay low. I would have used the word to get family members out of harm's way. That's what I would have used.
See, what he's saying is that he would have used that he gave him money to get out the way of harm's way because the ops may be coming to get you because they believe that you had something to do with the crime. That's what he's trying to say. But she's trying to say that they gave you money to lay low because you committed the crime to influence the activity of the RICO conspiracy. So you understand?
If I'd have gave you this, that's what I would have said. I wouldn't have said he gave us money to lay low.
Is it your testimony that you did not send those words to the state through your lawyer? Is that your testimony today?
I try to get my lawyer to change this because
See, she's saying that you sent these words to me through your attorney, so we're going to have to put your attorney on the stand to ask where these words came from. I may do a video on that. But that's what this is, that right now he's throwing it on his attorney. His attorney is praying for him and praying for himself that, man, I hope they don't get me jammed up. Because now all of a sudden he agreed to be a rat bastard, and now he's trying to flip it and say that, he didn't know that he was telling. And that I didn't explain it to him that he was telling. That's what his lawyer's saying. And this is not to disrespect Monk in no fashion, but this is for the youngins and the elders and the males and the females to understand how tricky this is when you get involved in a life of crime, and that's why we're trying to prevent you from going down that path. So sit back and let's listen.
my words was to get out of harm's way. I don't know how I still became lay low. My words and the notes that my lawyer took down, it was to get me and my family out of harm's way because on January the 10th, I was accused of the murder. By the streets, not by your district attorney office.
See, he's saying that he got money to get his family out of harm's way because he was accused of the murder that he had nothing to do with. And the prosecution is saying, no, you got the money per your statement that was sent to us through your attorney to lay low after committing this crime for YSL. It's not hard. This is what's going on here. All right, pay attention.
Understood. All right. Thank you for clarifying all of that. At what point, Mr. Sledge, going now to the sentencing acknowledgments, starting with number 1, where you say you understand it today, but did not understand it on December 28th, 2022. What happened to cause you to understand it?
What number 1 on the first page? You
Page
lost
5
me.
of 7,
Yeah, so you lost me.
under section 5. You want me to point it out?
You're being real nice.
That one. Are you with me?
Yeah, I'm looking at it.
All right. Do you recall telling the jury a few minutes ago, you understand it now, but didn't understand it on December 28, 2022?
I don't understand it now because I read it.
Is that the only thing that happened between today and December 28, 2022, which caused you to understand it, where you didn't understand it on December 28, 2022?
Yeah, I didn't understand it on December 28, 20, whatever day it was, because I actually didn't read it.
Did you?
See, he's saying, I didn't read it, so I don't know what happened. Well, she's going to get to later on that, well, your attorney should explain that to you, not me. And you should have read it because it was your signature and your life and your 35 years on the stand.
Hear it?
No, it was basically when certain things were said, I was stopping. So I don't recall this even being read to me.
Okay. What about number 2? What happened to cause you to understand it today and not understand it December 28th of 2022?
I just said it wasn't read to me,
Okay.
but I actually reading it myself, I understood now. But on the day that I signed, I don't even recall this even being there. I just initial.
Okay.
It was never read off to me.
See, and that's where they're going to say, well, it was your lawyer's attorney to read it off to you before you initialed it.
Is that the same answer for number 3,
Yes.
4, 5, 6, and the paragraph up under number 6?
Yes.
Okay. Thank you for clearing that up. So, going back to page 3 of 7, number 1. Do you remember yesterday I asked you, how were the crimes that you committed? How did you mean for them to boost the street credibility of YSL?
The booster street credit of YSL
Yes.
probably brought females around, people wanting to hang.
Did it make people scared of YSL too?
No.
Is the crime that you were referring to in count 1 that drive-by shooting that you
I
committed?
thought we couldn't talk about that, the drive-by shooting.
Oh, yes.
Yeah, oh, yes. You can talk about that drive-by shooting because you was involved in it. Now, where they're going at with this, so you understand it, she's laying it out, everything that happened, so he fully understand. Big dog, you agreed to testify, you agreed to be a rat bastard, and now you're sitting here trying to defend and lighten the load, off of us, the state. against YSL and Young Thug. All right?
You can.
My drive-by shooting?
Your drive-by
Yeah,
shooting.
talk about that.
All right. And is it your testimony today that you committed or participated in that drive-by shooting
Yes.
to boost the reputation of YSL to bring females around?
No, not. But what I was saying, like, I just don't think it was to boost the credibility. I never knew that the question even said to boost a notorious street credibility. I didn't know it was. I didn't know the question said that at the bottom.
See, what that really means is he didn't know y'all was gonna use this shit in court. You know what I mean? I thought I could just sign this, you know what I mean? Get on the stand, say what I wanted to say, get off the stand. But little Woody done blew the case up, so now y'all need more than, little Woody. So now you're coming into dealing with what I did, you know what I mean? And what I signed up to speak on, and that's what I'm supposed to sign up to speak on. But I ain't really trying to do that in open court right now where the world is looking at me.
I knew about the top part.
All right.
That's why I signed to it, because I knew me and Zachary and Gunnington
All right.
pleaded guilty to doing a drive-by shoot.
See, right there, they mad at that. He said that they all pled guilty, so that justifies why he's on the stand. They pled guilty, so we all agreed to plead guilty to this drive-by shooting to get out of our situation. But now that we pled guilty to get out of our drive-by situation, we thinking that we could just say that it was us that did it and we're not ratting. But now you want me to say more that it was us that pled guilty, meaning bringing in other people that didn't plead guilty, that's fighting for their lives, like Young Thug and his co-defendants. That's what's happening.
What about?
Okay. Disregard that anybody other
Oh,
than Mr.
say-
Sledge may have pled guilty to anything about this crime.
Right.
And I did admonish him.
See, right there, the jury is not supposed to know that anyone pled guilty. That's why the judge jumped in to say that. She's saying she did admonish him. He's getting ready to say, no, you didn't. You know, then he's going to switch it to, you might have did it yesterday, but you didn't do it today. Listen.
That.
No, you didn't.
Yeah.
Not today. Probably yesterday, not today.
Number 3, as it relates to you only, how did threatening to harm Shell Kale count as you're acting on behalf of YSL? What did it do for YSL when you threatened to harm Shell Kale?
It didn't do nothing because me and Shell Kale seen each other 1,000 times and that never happened. So it didn't do nothing.
Because who in Shell Kale?
I said, me and Shell Kale seen each other, me and him, seen each other 1,000 times and nothing never happened. So I don't.
You acknowledge within that statement that on behalf of YSL, you threatened to harm a person named Kale?
I never said I threatened. I said if he was looking for me, I had something for him.
All right. Do you remember earlier when you were reading section 3 of part 4 on page 3 that I asked you if any part of it was false, to tell me today you count it as false, to label it false?
I probably couldn't hear you. Probably couldn't hear you as clear, but I know for a fact, like, you in the video, I never threatened him. I just said if he was looking for me.
Okay. So is it?
Well, that part,
Testimony
I say
that-
that part down there is false.
Okay, so we're going to label that as false. Number 3.
Okay.
All right.
You're going to blame all this on the attorney for not explaining it.
Number 4, is there any part of number 4 that is false?
Yeah, the date, that's all I could see.
Okay. Other than the date, is there any part of number 4 that is false? Read it carefully.
Yeah, and I would say the video part.
So without talking about what part, just if there is any part that is false, please just tell me false.
See, I didn't even know how to say this. Yeah, that's false too.
All right. Mr. Sledge, did you read earlier when I was going over them? Did you read each of these?
I didn't read that part. I missed out on that. On the video part at the bottom.
Number 5. How many sentences is in number 5? Is there only one sentence?
No,
No, without reading it. Is there more than one sentence in number 5?
Yes.
There's more than one sentence.
No, it's one complete sentence.
Okay.
I'm sorry.
Now, did you read that one complete sentence a moment ago when I asked you about number 5 under section 4?
No, I didn't read it completely. I didn't read it and understand it at first, but now I do.
So with your new understanding,
It'll be false.
Okay. Number 6. Read it, please. Fully.
Defense admitted.
No, not allowed. Not allowed.
I thought you
Yourself.
said
My
read
apologies. My apologies.
I see what it say down there, but
Is any part of number 6 false? Because if it is, I would like for you to say false.
false.
All right. Now, do I have it correct that your testimony today is that number 3 is not entirely true?
Yes.
Number 4 is not entirely true?
Yes.
Number 5 is not entirely true?
Yes.
Number 6 is not entirely true?
Yes.
Number 7 is not entirely true?
Yeah, number 7 is not true.
Number 8 is not entirely true?
Not true.
Number 9 is not entirely true?
Not true.
And number 16 is not entirely true.
You said 16?
Yes, sir, on page 5 of 7 at the top. Number 16.
Yes, not true.
Okay, all right.
But you remember I explained to you about number 7, 8, 9. I try to get you the 10. I try to get you I say 7, 8, and 9. I try to get you to change at the time and you wouldn't change.
Okay. That's your testimony. All right.
He marking out his testimony because she's going to use that to try and get this board 35 years.
So, of all of the factual acknowledgments contained in section 4, from 1 to 16, is it your testimony today that the only ones that are true fully are number 1, number 2, number 10?
That was a misstatement of the testimony.
Then Your Honor, that was a question that he can correct if I have it wrong.
Overruled.
Okay. I'll start over. Is it your testimony today that of all the factual acknowledgments in section 4, from 1 to 16. The only ones that are true in their entirety are number 1, number 2, number 10, number 11, number 12, number 13, number 14, and number 15.
Yes.
Have you had enough time to carefully read those to ensure that I've accurately stated what your testimony is?
Yes.
All right. So if number 1 is true in its entirety, how were the crimes you committed intended to benefit YSL?
What you talking about? What, a hand signals?
No, sir.
Oh.
No, sir. You said that it was true in its entirety, didn't you?
Yes.
Number 1?
Yes.
So I'm talking about the part about committing crimes to benefit YSL. How have the crimes that you've committed how did you intend that they benefit YSL?
I guess to the street credibility.
What does that mean?
Street credibility.
What do you mean? You guessed.
I guess people notice YSL.
Notice what about YSL?
We'll handle our business, I guess.
What now?
We'll do what we got to do.
What does that mean?
Stand up for yourself.
Okay. Stand up for yourself how?
Defend yourself.
And what does that consist of for you?
She want him to say, bust your gun, man. That's what she's trying to get at.
What did that consist of?
I don't get what you're asking.
What did you mean when you said defend yourself?
Oh, defend myself from anybody in the world.
How did you defend yourself to show that nobody should mess with YSL? What ways did you do that? Is that a fair question?
I committed a drive-by shooting.
To show you don't mess with YSL?
Right.
Okay. All right. Thank you. All right. Was that drive-by shooting against a rival gang member?
It don't say that in that question.
I'm asking you.
I didn't consider it as a rival gang member at the time.
So how was that drive-by shooting going to show anybody that you don't mess with YSL?
Because they jumped on Gunnerton.
Oh, okay.
All right, Evan, and we're going to need to break early for lunch today to accommodate an issue with one of the jurors. So I don't know if I let y'all know that before, but we're going to break right now. We'll figure it out later.
Okay. Now check this out right here. This is called, hold up, I got to pause.
All right, go ahead, Mr. Sharp.
This is Mr. Sharp cross-examining him to show that he didn't know what he was signing. They tried to get him to sign that and trying to prevent him from testifying to what Miss Love, trying to force him from testifying to by giving him an out so he could see how he could get out this situation without having to fold to Miss Love and testify to the things that he initialed that he's trying to say he didn't know. So he's going to help to bolster that he did not know. All right? Which is ignorance is 1/10 of the law.
Thank you, Your Honor. May it please the court. Good afternoon, Mr. Sledge.
Good afternoon, Mr. Sharp.
All right. We had just, last thing I asked you was about your representation. Do you recall?
Yes.
Okay. And that you had not hired Mr. Wright for trial.
No.
Okay. On December 28th, 2022, okay, you were aware that, well, let me back up. Typically, have you ever had appointed counsel?
Objection relevant.
Just trying to educate on how it usually works. I'll move on. Okay.
Okay.
On December 28, 2022, you were aware of co-defendants on this case who had been arrested.
Yes.
And there were some of those individuals who could not afford attorneys, correct?
Right.
And you were aware that some of those individuals were in Rice Street,
Yes.
or they were in Rice Street,
Yes.
and those individuals that could not afford attorneys had not been appointed attorneys as of December 28, 2022, correct?
Yes.
Okay. And isn't it true that you did not want to be in their position?
Yes.
Meaning you did not want to be in Rice Street without an attorney?
Yes.
Okay. You believed, for the purposes of having representation, it was in your best interest to resolve your case via plea on December 28, 2022.
Yes.
Okay. Do you know what coercion means?
No.
Okay. What about pressure?
Yes, I know what pressure means.
Okay.
Pressure bust pipes. That's what he knows. All right. And they put the pressure and they bust the pipe.
Being in, and this is your truth. I'm not asking for a legal definition, okay?
Yes.
Okay. Being in Rice Street for 7 months prior to your plea, did that put pressure on you to accept this deal?
Yes, a lot.
Okay. Being separated from your sick mother
Watch
and
Miss
your
Love.
children.
This line of questioning is already been, so asking.
Your Honor, he testified for 3 days already. I've been going for 10 minutes.
And she's already interrupted me. She got 3 days of this dude. I got 10 minutes. This is what the lawyers say. Like, come on, Your Honor. What the heck is going on here?
Yeah, but you did already ask him that.
Well, I'm just trying to conclude this line of questioning, then I'll move on.
Okay.
I haven't asked him about pressure yet. He wanted to go home, and now I'm asking about pressure. Being separated from your sick mother and your children, did that create pressure to plead guilty on December 28, 2015?
Yes.
Excuse me, December 28, 2022.
Yes.
And the fact that you did not have a lawyer for trial, did that create pressure on you?
Yes.
See, what he's saying is, yo, this joint was pressure. She put the pressure on me to get my freedom. That's what he's saying.
That,
Ask and answer relatives goes beyond.
how about facts not in evidence too?
That's not an
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty?
object. That assumes facts not in evidence, and it also calls for speculation.
Overruled.
The fact that you had not hired an attorney for trial, did that create pressure on you to plead guilty on December 28, 2022?
Yes.
Okay.
Pressure.
All right. I want to talk to you about the plea offer.
Pay attention.
And when you need to, you can refer to it. But I want you to listen to my questions, and if you can answer without, that's fine.
Yes.
Okay. At some point in late December 2022, you became aware that the state was making a plea offer in your case.
Yes.
Okay. And the state's plea offer was an offer for probation.
Yes.
Okay. And probation, I know we know what it is, but for the jury, probation is you don't have to be in custody, right? You're released.
Yes.
Okay, and you have to check in with a probation officer.
Yes.
In your mind, that's preferable to prison.
Yes.
That's preferable to sitting in Rice Street Jail, correct?
Yes.
Okay. Probation would get you back to your family,
Yes.
get you back to your ill mother,
Yes.
and that would solve your issues as far as hiring an attorney to try the case.
See, what he's saying is that he was under pressure, man. They offered him probation, for him to sign this plea agreement with whatever they said, and they gonna let him go on probation, and he don't have to be locked up on Wright Street. So the lawyer, Mr. Sharp, is pointing out that homie was under pressure, man. You know what I mean? He did this under what they call pressure is another word in legal terms for. Let me see how to give this. Pressure is a legal term for coercement. They coerced them. They put the pressure on him. They squeezed him to get him to sign this by dangling the carrot of probation in front of him. And he bit the carrot. And this is what happens.
Yes.
You were interested in a plea for probation.
Yes.
Okay. Now, as it turned out, there were factual acknowledgments that you would have to initial to receive that offer of probation, correct?
Yes.
Okay, when you first learned about probation, did you realize that there would be factual acknowledgments that you had to initial?
No.
Okay, but at some point your attorney told you to get this probation, you're going to have to agree to factual acknowledgments.
Yes.
Okay. Let's talk about the factual acknowledgments.
Factual acknowledgments. Hold up. Now, the factual acknowledgments is the facts that Miss Love put in this plea agreement. You had to acknowledge and agree to these factual acknowledgments in order to get this probation and go home with a sick mother. Now, y'all be honest with me. How many of you would do this to go home to your sick mother? If you're one that would do it, you're on the right track. Now we just have to keep you on that right track by letting you know, don't get off the porch. Don't enter the street. Period. If you agree that what he did is right, I'm going to give you a round of applause. All right, calm down. From a civilian's point of view, I want you to be civilians and stay civilians. But if you choose to be on the street, bust your gun and be labeled and have your legacy be down as a gangster, you don't go in the courtroom and sign plea agreements such as this, because this is when cooperating with the state or the feds go wrong, because then you have to pay the piper. It's like, not calling the devil, but it's like making a deal with the devil. You say, make me a billionaire like Jay-Z, and then you could have my soul. And then when they come to collect your soul, you say, oh, I didn't know that you mean you're going to get it now. I thought you meant after I was dead. No, we're going to kill you and take your soul. Okay?
Do you remember the first time you saw the factual acknowledgments on that plea form? Was it December 28th?
Yes, I want to say yes.
Okay. Could it have been earlier? To the best of your recollection.
Yes, I think if I'm not mistaken, yes.
Okay. Did you ever write a statement with your truth about what happened in 2015 and give it to Miss Love or any other prosecutor in this case?
Objection vague as to your truth and what happened in 2015, made overall.
Did you say 2015?
I did. About what this case is about. Did you ever write a statement?
Objection
Oh, about, not in 2015.
No, about 2015.
Overruled.
No.
Okay. Did you ever sit down with Miss Love before this plea?
No.
Okay. Did you write the factual acknowledgments?
No.
Okay. On that sheet of paper in front of you, I believe it has, do you know what letterhead is?
I think it's the stamp, something like that.
Okay, on the top of the paper.
Yes.
Is there letterhead that indicates whose office that paper is from?
See, right there, this is where Miss Fannie Willis come in because they all work under her. So they showing the world how corrupt, Fannie Willis and everything under them is, because these are the games they play, because they're saying that he did not write the factual statement. She wrote out the factual statements of what she wanted him to say, not the factual statements he wrote out as far as what he knew what happened. This is what she felt happened and what Miss Love wanted him to testify to what happened. And that's what Mr. Sharp is getting at, so you understand.
It say Fannie Williams. That what you talking about? Right.
Yes.
Right
Yes.
there. Bingo.
Okay, from the Fulton County District Attorney's Office?
Yes.
Okay. Do you know who wrote the factual acknowledgments?
No.
Right there. It wasn't him.
Who presented the factual acknowledgments to you? Was it Miss Love?
Yes.
Oh,
Okay.
so
Did
she wrote him.
you know Miss Love back in 2015?
No.
Was she hanging out with you in 2015?
No.
Okay.
What he's getting at is that she didn't hang out with him in 2015, so she don't know the facts of what happened in 2015. All she knows what people like Woody and the other witnesses told her, so she wasn't in a position to write out the factual statements of what he was going to testify to. Only person was capable of doing that was Mr. Sledge.
I'm not trying to embarrass you. You're a smart man, okay?
Right.
This way he
But
get
you
him.
did indicate that you didn't know what the word notoriety means.
Yes.
And you've also just said you didn't know what the word coercion means.
Yes.
Okay. Could you look on that in that document with the factual acknowledgments? Should be page 3. I'm going to ask you to look at factual acknowledgement 1. On the last line, does it have the word notoriety?
Yes.
Okay. I'm going to look at factual acknowledgement 5.
Pay attention.
On the last line, does it say notoriety?
You sound 5.
Yes.
Yes.
I'm going to ask you to look at number 16. On the third line down, on 16, does that say notoriety?
Give me 1 second. You sound what line?
The third one down on number 16. That's page 5.
Yeah, I'm on page 5.
Okay.
Yes.
All right. Could you go to page 6 and look at the last word on page 6? Does it say coercion?
Yes.
And those are words to this day, I guess before this trial maybe, that you never knew the meaning of.
Still don't know the meaning of them.
Okay. Do you write sentences using words that you don't know the meaning of?
Objection, Your Honor. Relevance.
The relevance is he didn't use these words. He didn't know what she was talking about. That's not in his vocabulary where he completed school in the 9th grade and then went into 10th grade and dropped out before he completed 10th grade. That's the relevance. Let's stop the games, man. We see what's going on. You know what I mean? But he's giving him an olive branch, as they call it, to hold on to get out of this situation. Pay attention. I'm giving y'all an hour and change of this.
Sustained.
Now, in preparation of your plea, whether it was on December 28th or before that, you did speak to your attorney, Mr. Wright,
Yes.
about the acknowledgments,
Yes.
correct?
Yes.
And you brought certain acknowledgments that are on that sheet to the attention of Mr. Wright and told him you don't agree with those.
Yes.
See, right there is where they're going to put it on Mr. Wright. Mr. Wright got to go up there and say, nah, I told him what these terms meant. So he's lying, he's lying, he's lying. That's what he got to say to save his license, just so you understand. All right? So now they're putting on the lawyer. That was a lawyer's job to explain it.
Okay. And were you present for discussions that Mr. Wright had with Ms. Love or the state?
No.
Okay.
So in other words, he don't know what the hell they talked about when it was his freedom at stake. So this is where they could get the lawyer on ineffective assistance of counsel, because he should have been there or he should have explained it to him. So it all falls on him, not Miss Love. That's why she's so quiet.
But to your understanding, some of the acknowledgments that you did not agree with, the state refused to change, correct?
Yes.
Okay.
See, he's saying that he didn't agree with the coercion and all this stuff that he didn't understand, and the state, he thought was going to change it. Listen.
And you wanted to go home?
Yes.
You do anything to go home.
Did you let a disagreement with those acknowledgments stop you from getting home to your sick mother?
Objection, speculation.
In other words, you'll sign anything to get the hell out of jail to go home to your sick mother. Now, y'all watching this, would you do the same thing? Put that in the comments. Be honest. And we ain't going to bash the people that say one way or another. I just want you to understand, when you on the street, they lock you up. You can't say, I'm trying to get home to my sick mother. I did 20. Let me ride. Another ride. I did 26 years in federal prison. My mother went on the run for 7 years because they was trying to get on certain charges. And she said, baby, you do what you got to do. I do what I got to do. That meant you stand tall as a man, and I'm going to do what I have to do and stand tall as your mother. And I'm going to elude these people for this 7 years to get the statute of limitation out. So I didn't even talk to my mother for 7 years on the phone in federal prison. Could you imagine not calling your mother for 7 years when you wanted to and you had the opportunity, but you knew if you called her that they'll trace the call, track her down, and put her on the indictment? This is all the crap I had to deal with that I'm trying to prevent you from not having to deal with. Don't put your mother in harm's way like Sean Gothright did in the Fulio case by driving his mother's car to the ultimate #1 crime, which is to take someone's life, which is to unearth them. Unless your mother's down with it or know what time it is. It's on you how you play it. You know what I mean?
And
I said, did you let?
objection as to the form of the
They're
question.
playing games with the word somatic. They playing word gymnastics right now.
Objection.
Can you rephrase your question?
You know what he
Those
said.
disagreements with the acknowledgments, did you let those disagreements get in the way of you getting home to your sick mother?
No.
Objection, Your Honor.
See, they know that he's touching on the emotional cord of the jury when he's saying that he signed the agreement to get home to his sick mother, and he would sign anything to get to his sick mother, as the civilians will. But if you're not a civilian, there's nothing that's going to make you testify against your comrade. Not even if your mother is sick. All you could do is pray that your mother stay alive until you come home, like I had to do for approximately 3 decades. And that's where we at. All right?
I mean, you basically asked the same thing, the same way. You just moved the the phrasing around. I don't really know. Can you rephrase it again?
Okay. Can I break it up?
You
Okay.
can try.
You disagreed with some of the factual acknowledgments that Miss Love presented to you, correct?
Yes.
Okay. And you brought that to your attorney's attention.
Yes.
And you were told that the state was not going to change those factual acknowledgments.
Yes.
Okay. On December 28th, 2022, did you let your disagreement with the factual acknowledgments stop you from entering that plea?
No.
Why not?
Because I wanted to go home to my sick mother.
He playing on it. He caught it.
You have, during direct testimony, when Ms. Love was asking you questions, you've stated that you disagree with several of the factual acknowledgments in this plea agreement that you signed, correct?
Yes.
You know, but you let Miss Love know. He's saying he let Miss Love know what time it is. Yo, I don't agree with this here, but I'm trying to get on my sick mother, so bring it on. I'm going to sign it. And that's where they're getting at.
Okay. You watched the video of your plea earlier today, correct?
Yes.
Okay. Those acknowledgments on that video, who was reading those acknowledgments? Was it you or Miss Love?
Miss Love.
Okay. When you were saying yes, ma'am, do you remember that? So
Yes.
pretty much every question, is that fair?
Yes.
Weren't there times during that plea, during that video, where you were saying yes, ma'am, before Miss Love even asked a question?
Yes.
Right there. In other words, man, I'm just trying to get out of here. I don't know what's happening. I just want to tell what y'all want me to tell me and go home to my sick mother.
Why were you saying yes, ma'am, if you disagreed with the factual acknowledgments?
I was just trying to get home to my sick mother.
Bingo!
Okay. Did your attorney tell you, or you testified that your attorney told you that you could explain those disagreements later, correct?
If I was called into the stand, yes.
Heard that key word, if he was called into the stand. So he thought that if he signed that, that'd be the end of it. He wouldn't have to be called to the stand because we might not even use you. You know, just like they said, they might not even use Gunner. Well, we're going to see what happens. Let this play out. So y'all can make your speculations on Gunner, not bashing Gunner because he took his plea, you know, but I just want y'all to see how this game is played out because you get to see firsthand what I had to sit through for 2.5 weeks watching my trial go out with my comrades doing this.
Okay. And you were advised not to let those disagreements get in the way of going home, correct?
Objection, Your Honor. Objection as to attorney-client privilege. Objection as to hearing.
Bottom line, stop the crap, Miss Love. Bottom line is, did he have a chance to go home? What was going on? Let's go on with this so we could stop the bull crap. All right?
Say objection as to an improper line of questioning to an improper topic.
Okay. Sustained on facts not in evidence.
Okay. When you came to testify in front of this jury, you were under the impression that you would be able to explain what you disagreed with, correct?
Yes.
See, right there. He's saying that I just signed them because they said I can explain what I don't disagree with later, but she's holding them to no, you signed them, so you agreed to do this. End of story. This is what I told y'all I needed you to say. This is what I needed you to say happened, and you agreed that you would testify to it. This is your chance to testify. That's the end of story. There was no, you could come back and explain yourself later because you could have asked whatever questions you wanted at that time because you had your attorney present. Stop it, Mr. Sledge, is what Miss Love is saying.
Do you know the saying, you're between a rock and a hard place?
Rock and a hard
Yes,
place.
I heard that.
Okay. Do you consider yourself in between a rock and a hard place right now?
Yeah. Yes.
Okay. The rock is that you know some of these things in this plea agreement aren't true, correct?
Yes.
The hard place is you don't want to go back to prison, do you?
Yes.
Yes, you do not want to go
I
back.
don't want to go back to prison.
I tell anything, I tell them not to go back to prison. That's what they trying
And
to
the
get.
problem is your plea agreement, correct?
Yes.
Let's talk about this plea agreement. In this indictment, you were charged with 2 counts, correct?
Yes.
Count 1, RICO,
Yes.
or conspiracy to commit RICO, I should say.
Yes.
And count 30 was a gun charge, correct?
Yes.
Specifically, possession of a firearm by a convicted felon.
Yes.
That's the one that could get him 15 years in prison, running bow-legged to the official RICO charge. That's why they speaking on that, because this is what the pressure was about.
For count 1, let's talk about that, what the plea agreement was, okay?
Yes.
The agreement, if you initialed the factual acknowledgments and entered a plea, the agreement was that the state was going to recommend 15 years of probation.
Yes.
And that meant that you would get out of jail immediately.
Yes.
I'm going to ask you to look at Part 5 of the plea agreement, number 2, under defendant's sentencing acknowledgments.
What page is that, Mr. Sharp?
That's page 5.
Okay. And what number?
It's number 2 under section 5.
Yes, I'm looking at it.
Your agreement states that defendant, that's you, right?
Yes.
Okay. Defendant understands fully that if he violates any provision or any special condition of the plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections. And in parentheses, it says prison.
In other words, Trigger, you're looking at prison, man. If you don't testify truthfully in the manner that I laid out in this joint, you will be in the Georgia State Prison. Stop it. So you're working for us or you're going to play hardball.
Is that accurate?
Yes.
Okay, so let's break that down a little bit. You're aware that a condition of your plea is to testify consistently with the factual acknowledgments you signed.
Yes.
Mind you, that's the factual acknowledgments that the woman in the pink jacket made for him to acknowledge all the facts, even though she didn't know him in 2015. with the facts that she's speaking on in 2023 for him to testify to in 2024.
That you say are not true.
Yes.
And according to this agreement, if you fail to testify consistently with those acknowledgments, the state can move to revoke your probation, correct?
Yes.
Do you know what revoking probation is?
Yeah, I think take it back, send you to, however, take the probation back, revoke it and send you to prison.
Okay, so if you have 15 years remaining on probation,
Yes.
the state can bring a motion and ask the judge to send you to prison for those 15 years instead of being on probation, correct?
Yes.
Okay. Let's talk about the agreement for count 30, possession of a firearm by a convicted felon. Okay. Your lawyer told you that count,
Sustained.
you were aware that count carries a mandatory 15 years in prison,
Yes.
and that 15-year sentence needs to be consecutive to any other sentence that you have.
Yes.
So they holding the 15 years over his head so that they could wind up giving him the right to testify and be on the state's attorney's team and not have to do this 15 years. He pled guilty to it already, but they saying that we allow you to come back and withdraw your guilty plea and then sentence you by throwing the charge out. Would you go for that? Be honest, put it in the comments. If you'll go for that, you're on the right track. And my next step to you is stop breaking the law or don't break the law, because you're on the right track. It's not worth it because you got to play hardball and take that time. This man should have been sitting on the stand with Young Thug if he was playing by 100% of the street rules, but he tried to manipulate it and it didn't work. And it's not to disrespect him, because it's going to be a lot of y'all that's going to try that. And that's why I'm preventing you from trying to try that, by letting you know, don't get involved in the street. You don't have to be put in Monk Tonk situation, Little Woody situation, or anybody else. This trial is perfect to break down exactly what is going on so you understand. All right, let's go.
It would have to be 15 on top of the 15.
Yes.
That's 30. But they added up to 35. Watch this.
On page 1, under negotiated sentence, it says, where it says count 30,
Pay attention.
You said page 1?
yes, page 1, sir.
Okay. Yes.
Pay attention.
It says, for count 30, that was the possession of firearm by a convicted felon, correct?
Yes.
Okay. It says, sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant, that's you, right,
Yes.
has complied with the special conditions outlined in sections B, C, D, F, and I of Section 3, special conditions of sentence of this plea agreement, the state agrees the defendant shall be allowed to withdraw his plea on count 30, and the state shall agree to no pros count 30. That's what it says, right?
Yes.
Okay, so let's.
That means that the state can allow him to withdraw his plea, and then they'll go in and throw the case out if he satisfied him with his testimony that he's given. Now, Ms. Love pulled this out to show the plea agreement to him, to let him know you're not satisfying it, and let the judge know he's not satisfying it, and I'm planning on giving his black ass 35 years in state prison in Georgia, or the Georgia Department of Corrections.
Talk about what your understanding of what this means. On December 28, 2022, you pled guilty to possession of a firearm by a convicted felon.
Yes.
Okay. And under normal circumstances, that would be 15 years in prison consecutive.
Yes.
Okay. But
so we talking about 15 years here. So would you testify and testify to what Miss Love, wrote out in that plea agreement to not get this 15 years added on to what you're looking at for the RICO case?
The state in this agreement allowed sentencing was withheld, correct?
Yes.
So you weren't, even though you pled guilty to count 30, you were not given a sentence.
Yes.
You were not given 15 years to serve in prison.
Yes.
And sentencing was withheld until after this trial.
Yes.
Okay.
All right. So in other words, after this trial, if we convict Young Thug and we're happy with your testimony, then we'll allow you to come back and pull back that 15 years. I'm spending almost 2 hours breaking this down, but I really want y'all to understand, because this is important for y'all to know, not to get involved with street activity or street crime. That's all the message is at Unique Mecca Audio. It's not to bash Monk Tongue. It's not to bash young, how they pronounce it, Woody. You know what I mean? Or Woody. You know, because it's not to disrespect them, not to bash them. It's just to use this as a tutorial, because it's the first street trial that's being publicized to us, where we could see it in real life time to see what happens behind closed doors.
And your understanding is if you testify
Pay
in
attention.
accordance with this plea agreement, the state will dismiss that case.
Yes.
Even though you've already pled guilty to it, the state will go back, let you withdraw your guilty plea, and dismiss the case.
Yes.
You've been in trouble before, right?
Yes.
Okay, you
Heard that he's been in trouble before, and the state is saying, plead guilty to this gun. If you satisfy us on this trial and we get Young Thug convicted, we're going to throw this joint out. Look at this commentary. That's why the Cash App is on the screen. I mean, I don't understand how hard this is. You know, come on, man. I'm saving your life.
ever have an agreement, a situation like this in any of your other cases?
Sustained.
In other words, have you ever been blessed like this in your life in a court of law, where you could plead guilty and then come back after you testify and convict your comrade and bury it in prison for decades or life, and then be able to pull your plea back and get a whole new sentence? Would y'all go for that? Y'all tell me in the comments and be honest. And like I said, I'm going to say it again. If you go for that, you're on the right track to being a civilian. Stop the bull crap you're doing, man. All right?
I'm going to ask you to look at part 5, number 4. Okay, and that's under defendant's sentencing acknowledgments. You with me?
Yes, I'm with you.
It's on page 6, right?
Yeah, 6, 7. Yeah, I'm with you.
Okay. Number 4 says, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in his plea agreement, such failure or refusal nullifies. Do you know what nullifies means?
No.
Okay.
Right there. Nullify meaning to kick that shit out, my nigga, and bring you back in court and give you this 15 plus to whatever for the RICO.
It says nullifies though, right?
Yes, it say that, but I don't know what it means.
Nullifies any promise made by the district attorney to no pros count 30 of this indictment. Right?
Yes.
And to your understanding, regardless of whether you know what nullifies means, if you don't testify consistently with the factual acknowledgments that the state wrote,
Yes.
they will take back their promise to dismiss count 30 and you'll be sentenced.
Yes.
Right there. So you're going to say whatever you need to say, sign whatever you need to sign to get home to your sick mother. Is that what you're saying?
And you have to get 15 years in prison,
Yes.
consecutive to the probation that would be revoked.
Yes.
So that's revoking the probation for 15 years, giving them 15 years, and then giving them 15 on that. And what's gonna help you, right here? Y'all know Monk Tunk, so y'all know that I ain't bashing nobody. I'm not on that, because a lot of you youngins don't know. If y'all know Monk Tunk, let Monk Tunk know that the lawyer just threw him a life raft because she took 15 years for the probation that he'll be revoked from, and the 15 years for the gun that would have to be run consecutive, aka bow-legged, means separate, not together, separate, that he will get 35 years. When she put the 35 years, added the extra 5 years on there, and Monk Tunk signed that, saying that he'll take the 35 years, that shows and prove that he'll do anything to get out of jail, meaning even take an extra 5 years. Just let me out today to go back with my mother. I don't know what I'm signing. I'm even signing to this extra 5 years that you can't show me nowhere in this plea agreement that goes for. And Monk Tunk, that's what's going to help you, big bro, from an old ex-criminal point of view. Check it out.
Can you look at number 3 under section 5? So I'm on page 5 now, going into page 6.
On which
Says, defendant understands fully that any violation or of any provision or any special condition of the plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law.
yes,
Okay. All that on that video talking about he has to testify truthfully. In your mind, who gets to determine whether you testified truthfully or not?
Objection, relevance, and objection.
That's a really good question. Who decides if he's testifying truthfully or not? Common sense, we know it's Miss Love, but they don't want that being presented to the jury, that he have to satisfy Miss Love in order to get the 15 years for the probation and the 15 years for the gun, and not get the extra 5 years that she threw in there. Gunshots. Let's go.
Improper and vague. Who gets to determine?
He was about to answer. He knows what I'm asking.
He know what he's asking.
Question whether it's true or not. But determining whether something is true is irrelevant.
It's
Rephrase your question.
who gets to revoke your who moves to revoke your probation if they're not happy with what you say here today?
She don't want to say.
Objection. Objection, Your Honor.
Unfair characterization. What is your objection?
One, yes, that.
I said who moves.
Relevance, it is not a fair characterization, and the terms of the agreement that Mr. Sledge entered into have already been put before the jury, and the characterization that is being made at this point is improper and not relevant.
Yeah. We're going to stop it here, man. We're going to stop it here. I done gave y'all 2 hours of a breakdown for this. If y'all don't understand the importance of this and how this could save your life or your loved one's life by me breaking this down, and you don't feel that this deserves a cash app, understood. But this at least deserve, if you subscribe, hit the notification bell. If you not subscribe and hit the notification bell. And most definitely, all this is free. The notification bell for the subscribers, the subscription and the notification bell, and the like button. Come on, man. I'm not asking for too much, am I? But like I said, my phone number is on the screen, 917-680-9091. If you got any content you want me to break down in detail like this, please send it. If you want your name said that you contributed it, please put your name in the text to the number on the screen, 917 680-9091. The main thing is to hit the notification bell. Everybody that's subscribed, just hit that little bell button and it'll pop up and say all notifications. Hit the all notifications. The Cash App is on the screen for those that want to take it a step further and respect that the game is to be sold, not told, and I just gave y'all 2 hours of game. The Cash App is on the screen. Make sure you hit the icon, and it says that the account was created in 2020, and then it'll say Mecca Audio LLC. That's me, but it has to say it was created in 2020. Cop the book, Aurora in Harlem. All right, I'm going to flash it right here. I'm putting it back. Cop the book, Aurora in Harlem, at aurorainharlem.com. All right.
Cheers to the crime.
Fresh out the can, I'm 26, heat back on the strip, getting back in the mix. What he mentions a gift. You stand up 10 toes down, and I suggest you pay attention to this. Take a little gully posse and put it in hard. Cut from the bottom, came up from the bottom. Drop the book, you should go and get it. An Instagram page and a YouTube, you could go and visit. Then you could consider yourself LinkedIn. Sit front row and get juice from a kingpin. I went through it, so you ain't gotta go do it. Did not pay attention with the stupid. Talking about a man that probably put your grandfather on. Probably the reason that him and your grams got along. A man that generated millions on the block, did his time, never swilling to the cops, Mecca Audio. Get it live like 2 G's in the 90s. Drop top beamer so shiny. I let shorty go, she was whining. Treat her like my past, she behind me. Spend a couple bands on the dapper can. You be back again, getting green like a Packers fan. No cap, just a roaring uptown. Baby horn uptown, Dominican bust down. Now we on the positive, we got a lot to give. Now you trying to stop the kids from being inoperative. So take heed, homie, lend a ear. He started in uptown, he gon' finish there. But now it ain't about selling drugs, buying cars, it's about buying property to make the community yard. So we can